today with Scott Horne. Scott is a attorney extraordinaire out in Texas and has probably bought and sold about, what is it now, Scott, about 10 billion houses?
Well, something just short of that.
Something just short.
Yeah.
I know, but needless to say, guys, he's an expert in this, both buying subject to and selling with seller financing. And yeah, as most of you guys know, that's all I've done for the last 11 years or so. We redid our business about 10, 12 years ago, and all we do is buy subject to and sell with seller financing. So I thought Scott would be a great person to have on here. We did a podcast a couple of weeks ago and had a great time, and thought you guys could get a lot out of it. And he was gracious enough to take time out of his day from making money and helping other investors and come talk to us. So Scott, just want to welcome you to Goat Talk today.
Well, thank you. Let's do that. It'll be a lot of fun, I think. This is a topic that's near and dear to the heart, and it's always fun to talk about it and talk to a guy that actually likes doing it as well.
Yeah, it's funny, you know. I got the name Goat a couple of years ago when my students started mentioning, and that I would never be bold enough to call myself the Goat. I thought it was interesting though. When I talked to you on the podcast, you said that's a name that they call you around your office and the people that you work with.
Well, the difference between you and me is they call me the old goat, sometimes the smelly goat, but that's also the name of our asset-based lending, hard money lending company here in Texas as well, is Goat Funding.
Goat Funding. Okay, so great. So we've got.
And by the way, just like you, William, I did not come up with that name. It was given to me.
Right. So we've got Scott, the old goat, and William, and then we got Wally back here. So we got the three goats this morning. So, all right, Scott. So, you know, we've had a couple of questions sent in. We said we were going to focus this morning on buying subject to and seller financing. I want to encourage everybody to ask questions. If you've got some questions about these topics, don't hesitate to ask. That's what we're here for, and we'll try to get them all answered. And as usual, Scott's offering an awesome freebie for everybody this morning that participates. So make sure that you ask your questions. So Scott, let's start with the obvious question that most newer investors have when they get started, and that I hear in the forum all the time. Is buying subject to legal?
Oh my goodness. Well, how about the short answer? Yes.
Okay.
You know what, William, I find it so interesting that I go back, you know, prior to 2009 when the crash was hitting, you didn't see a lot of sub-2 acquisitions at all in the marketplace. Of course, you know, back in those days, if you could fog a mirror, you could get a loan to buy a house, right?
Right.
And we saw a lot of this back in the even prior to in the 1990s and late 80s. You didn't see a lot of it. You had the old FHA non-qualifying assumables, but interest rates on those mortgages that you could have gotten at that time were a little bit higher. But in 2009, you know, when the whole world was collapsing around our ears, you couldn't get a loan to buy a property. Buyers couldn't buy, sellers couldn't sell, you name it. It had all the problems, right? Mm-hmm. And this strategy came to the surface very quickly. And everybody had forgotten about it, at least around here in the Texas marketplace. Nobody knew how to buy a home using creative finance. And we'd go out and we started putting together what I call our disclosure packages that we use, that we provide to investors to make sure that buyers and sellers have full disclosure of the transaction. You'd go out and you'd present this to the realtors, because realtors were dying on the vine at that time. Texas had some 200,000 realtors, and over half of them went out of business because nobody wanted to think about the seller finance strategies, because everybody thought it was illegal. It was amazing. You talk to these realtors and even to the brokers, and you get this arm crossing going, I know what y'all want to do. You can't do that. And name the reason why, okay? And I want you to keep in mind the 4x4 strategy here in a moment, okay? But everybody thought it was illegal because realtor one would talk to realtor two, would talk to realtor three, and just propagated it. So as far as I know, here in Texas, oh, no, buying a property subject to the debt is not illegal. Our contracts have provisions for that. We have our seller financing addendums. And the Texas Property Code even has a revision, it's 5.0, 5.016, I think, where if you're going to sell a home and leave an existing loan in place, there's a certain disclosure notice we must give every buyer. And if all that stuff holds true, it cannot be illegal. But the fallacy, as you know, is that people in the marketplace, whether they're investors or realtors, they, because of the due on sale clause in existing mortgages, that's where they come up with the fact is they think that it's illegal. And it's not.
Mhm.
You know, it might be a breach of contract, you know, with that existing mortgage, but there's nothing to do with legality one way or the other.
Right.
And when you saw all these things, William, and I'm sure you confronted these things as well and ran into them, is you'd be talking to realtors, brokers, and sellers, and you're getting all this pushback, right? And so we came up with this strategy. We called it the 4x4 rule, which was how to eliminate 98% of anyone's negativity right up front. And the 4x, I call it 4x4 because here in Texas, everybody owns a pickup, right? Every pickup's a 4x4. So it's an easy thing to remember, at least here locally. And of course, the first part of the 4x4 rule are the four people to include in every owner finance transaction. That is a knowledgeable real estate attorney. It would be maybe a note pro, someone like myself or you who has the knowledge of how to structure a deal properly. It's the RMLO, the residential mortgage loan originator, and a loan servicer, if and when necessary. And then it's the compliance side, and that is with the SAFE Act, understanding it, make sure you comply. It is with the Dodd-Frank Act. It's with RESPA, and here in Texas, the Texas Property Code. Now, the beauty is, of course, when we're buying a house subject to, we don't have to worry about all this compliance issue because the SAFE Act and Dodd-Frank and RESPA doesn't apply in those instances, but disclosure does. But I found that when you meet those requirements and you present that properly to that seller, to that realtor, you can eliminate 98% of all the questions and negativity they have up front, and you get over these hurdles quickly.
Yeah. I know when, I'd worked out of the country for years and just recently moved back last year, and trying to find an agent here locally, we must have met with 40 before we found just a couple that were even open to what we were talking about. It's still a big problem. It's amazing, really.
One thing I do, William, in talking to realtors, it's all about, to me, it's about presentation. It's about knowledge. And, when I'm talking to a realtor, especially one who may be pretty good, they're not taught this first off. Mm-hmm. And, sellers who are selling their home in these scenarios, usually they're in trouble. They have some issues going on in many cases. But it's really just letting the realtor know that, this is not a strategy for everybody, but it is a strategy so that when they run across a difficult situation, instead of saying, we can't help you, this is a possibility. And then what that realtor needs to know is they need to have a go-to resource. Right. Whether it's someone like yourself in Colorado, maybe like us here in the Texas marketplace, or another very successful and knowledgeable investor in other marketplaces where, they can go and ask questions, garner resources, because a realtor's job is to market a property. It is not to advise a seller of what subject to is, how it works, why to or not do it. That would be someone's responsibility, like either myself as an attorney, maybe an RMLO who is knowledgeable in the industry, who doesn't mind doing that, or again, a very knowledgeable investor.
Yeah.
I think when you present it to them the right way, you can show them how it can be a tool for them to use when the time comes.
Right. Hey, Cindy, Matt, good to see you guys. Jonna, Rudy, good to see you. Matt says, and you had just mentioned something about a loan servicer. Says a lot of people seem to skip out on that. Do you actually need one? What's your opinion on that, Scott?
Well, when we are buying a house and we're doing the subject to strategy, my first response is no, we don't, because we can pay the lender direct, right?
Mhm.
And our seller can have the easy opportunity to verify and validate payments by going online. So the loan servicer, unless there's something odd going on, maybe where the seller is not collecting escrow or their mortgage company is not collecting escrow, which happens occasionally. We don't see a lot of that out there. But the seller wants to collect escrow, maybe you would incorporate a servicer in that instance. The loan servicer really comes into play when we are selling a home to a back-end consumer, because that loan servicer becomes our fraud preventer.
Mhm. Okay. All right. So in your opinion, it's a wise thing to do. It's not legally something you have to do, but it's just
Absolutely
an
not.
extra, maybe a bit of insurance.
You know, when you're using a servicer, so again, when we as investors are buying a home this way, I rarely recommend the use of a servicer. We just want to pay the lender direct. Make sure that the seller knows how to go online, verify payments being made in a timely fashion. They can take care of things. And again, as I said, the loan servicers in this industry did not exist prior to 2009. They weren't out there. It's only because of the fraud factor that can occur so often out there. We see it all the time. What we don't want is we don't want a homeowner to pay the investor, and then the investor, of course, not pay the mortgage company.
Well,
And unfortunately,
yeah, you guys had some big problems out there. In fact, you had one guy in particular that did so much of that. I think that changed some legislation.
well, they did, and that's where they were selling things. And in that instance, it wasn't the servicing; it was the fact he wasn't qualifying his buyers. His
Right.
buyers had a down payment; they just couldn't make a monthly payment.
Right. Gotcha. Okay. So Rudy asked, what is the best way to find an attorney who's experienced with subject to, or even, and I'll take it a step further than what Rudy said, because when I found my first attorney that I worked with in Georgia, when I first got started, I talked to two or three. Most of them were younger. They hadn't been around. They didn't understand how things worked. But I talked to this old guy who had been around. He'd been an attorney for like 40 years. And when I sat down with him and said, okay, his name was Wayne. I said, okay, Wayne, this is what I want to do. And he said, I don't see why we can't. Let's do it. So how do you find that guy that if you're not asking him to do something illegal, he's open-minded enough to
Yeah.
go along with it?
What we do is we actually do closings across the country for real estate investors, whether they're buying or selling using creative finance. Uh, of course, they might buy a house from a seller using a wraparound loan based on who that seller is. They might be using a subject to strategy as well. What we do is we act as the escrow agent for the closing. And of course, here in Texas, we can draw up all of the legal documents, but in other states, we cannot. And what we do is we work with the investor in a way where we provide them the disclosure packages in that regard, so they can attach that to the contract that they're using. And then what we do is I go and I call the local RIAs in the city where we are closing a transaction, whether it's been in Washington State or in, say, Alabama, Michigan, Florida, North Carolina. What we do is I try to find that investor friendly attorney first off. And a lot of real estate investment clubs have that, or they know someone who they close with on a basis. And then what I do is I reach out to them and walk them through what we're doing. I share with them the documents that we use here in Texas and what our deed looks like and what our deed of trust looks like. And of course, we have to realize that every state has a little bit different documentation.
Right.
Their deeds are a little bit different. Their deeds of trust are different. And I then let that attorney prepare for us the legal documents. I let that attorney tell me what if that state has any specific requirements. Like here in Texas, we have what is called the underlying lien disclosure notice, which is a notice that every seller must give a buyer at least 7 days prior to closing if an existing mortgage is being left in place.
Right.
Well, does another state have that requirement or something similar? I don't know. Do they have specific recording information? Do they have a transfer tax that we have to consider? We can incorporate all that into our settlement statements as we're closing the house, whether we're buying it as an investor or selling it as well.
Okay.
That's
So,
what I do. I want to go find that person who works with investors within that state, who deals with the things we do, because even if you're doing traditional real estate out there, whether it's wholesaling or whether it's the fix and flip, they're still dealing with investors, and they'll have some common sense on how to help us out.
okay.
Excuse me.
All right. Bless you. Okay. So let me get this clear, because I've already got Joni on here asking about it. And so you what you're saying is you can help facilitate a closing for an investor pretty much anywhere in the country if they contact you. And what you'll do is you'll just reach out to various attorneys and try to make sure they understand what's going on, because you can speak a language a lot of new investors can't speak.
Yeah. Well, all we're doing is, in the traditional mortgage world, mortgage companies use these law firms that are doc prep firms. And like here in Texas, there's 3 or 4 major doc prep firms, and the mortgage companies call them to prepare a standardized closing package, whatever that might be.
Right.
We're doing the exact same thing. We're not going to that attorney necessarily for legal advice or representation. What we're doing is simply ordering up documents that will be state specific, and then to inquire that attorney if there's any other state specific issues that must be addressed. The good part is that when we're buying a property, William, a settlement statement, a HUD-1, is the same in any state, right?
Right.
When we're selling a home to a consumer, a closing disclosure is the same in any state. The only thing that varies really is the note, the deed of trust, or the warranty deed. And then if there's any nuances, as I said earlier, like some states have a transfer tax on real estate.
Right.
Some have different recording requirements. We want to discern those so we can incorporate that into the transaction and close. From there, we just act as, to me, disclosures, and I know we've talked about this before, 90% of this business is disclosure.
Mm-hmm.
It's making sure that our seller understands what's going on, what the ramifications are, and it's making sure that our buyers and even us as investors understand it. And we want that disclosure there, part of the contract, to be done properly. And I am a huge believer in full disclosure, and then giving our seller on a sub-2 arrangement time to review the paperwork before going to closing, and not just do it a day later or 2 days. We want to give them time to go out and seek counsel if they wish to do so. Unfortunately, as you and I both know, they never do.
Right.
But we provide those disclosure packages that are valid anywhere across the country, I believe. And because the facts are still the same, whether it's here in Texas or in Colorado or anywhere else.
Yeah. Okay, Scott. So we already had several people comment here. So let me go ahead and get you to give us your contact information if they want to reach out to you about a closing or anything. So what's the best way to get in touch with you?
So our email address or website is hornerealestatelaw.com. And William, that's Horne with an E, so HORNE, realestatelaw.com.
Okay.
My email is scott@hornerealestatelaw.com.
Okay.
I would forward that over to one of my girls or one of the other attorneys here, and we can reach out and, of course, help any of your students out there.
Okay, great. So you guys got that. So the best way to contact Scott is hornerealestatelaw.com, and his email address is Scott at the same URL. So if y'all want to reach out to him about doing some closings. A couple of questions. Can you talk about some of the mistakes you've seen investors make when buying sub-2 and how to avoid them?
Oh my goodness. How long do we have, William?
Well, yeah, that's what I was just thinking. Gee, we only have another 30 minutes or so. I don't know if that's going to do it. That might be part 2.
I think first and foremost, is they need to ensure that this know how to convey to the seller what they're doing properly and correctly. And you want to do that the first time out of the chute, because we only get one shot to do this really well. But I think having a good knowledge base is so important. Number two, so often what I'm seeing today is that our sellers are oftentimes behind in payments, which is one of the reasons why we get a chance to pick up these properties. And if there is a foreclosure ongoing, it's in some foreclosure mechanism, and we need to get a reinstatement agreement, I like to have the seller contact the mortgage company while I'm with them.
Yeah.
Maybe I'm on the phone with them.
Right.
And let's get that reinstatement ordered as soon as possible so we can go to closing quickly and get legitimate information. Next, it's understanding that if a seller is in foreclosure, mortgage companies oftentimes stop sending mortgage statements and they send a different document. It looks like a mortgage statement, but it's not. And you want to go, maybe you need to go back 2 or 3 or 4 months to get a more current statement that will have all the information on there: loan balance, interest rate, principal, interest amounts, escrow being collected, whether or not mortgage insurance is part of that. And it's getting the right information as fast as possible up front. I think that's important. I think it is ensuring that if you're going to play in this game, it's recognizing that we're dealing with the seller's largest investment they have ever bought before in their entire life, and maybe ever will again, and we're dealing with their credit. What we want to do is use everything in our power to ensure we honor that and take care of things. And if we're going to play the game, then let's make our payments timely. Let's try to maybe get a payment ahead if possible as well. I know a lot of people can't do that, but whenever we have that ability, I think it's a wise thing to do. It's just a protection measure out there.
Right.
I think oftentimes, and especially right now, when we're buying a home sub-2, do your homework online through your county clerk's offices. There are a lot of HUD second liens out there I see where the seller had done a loan mod. And as you know, William, they'll take the arrears, put those into a second lien, usually bearing no interest and no payments.
Right.
What happens, I see, is that these sellers, they, out of sight, out of mind, they don't tell you that that's out there. And so sometimes I've seen students buy properties without checking title and things of that nature first. And here this lien pops up. And they're going, what's this? Well, of course, the seller didn't tell them because they forgot about it. And so, again, I think the ability to research your title appropriately is so important to do as well. Along the way, learning how to read a mortgage statement right, especially when there are arrears. I've seen situations where they'll look at it and not realize that with a reinstatement amount, that might just be for the loan, but very possibly the mortgage company has already paid property taxes on behalf of that seller. And that large amount could be hanging out there and not part of the reinstatement, and it gets missed.
Yep.
And then all of a sudden it's an amount due and outstanding. And then I think one of the biggest issues, at least I see around here, is probate scenarios. When a spouse has passed away, or maybe both spouses have passed away and an heir is out there, we've got to get some type of probate information. Here in Texas, we use heirship affidavits. I'm not sure what that is in Colorado or other states. And provide that to the mortgage company so that that heir can start communicating with the lender properly. I think those are all important things that I see out there in gathering it. And then from there, it's going back to what I just said. Full disclosure of that seller, ensuring they understand the deal, they understand the risks. Because what we don't want is we don't want that seller to call us back up 6 months later, 2, 3 years later, and ask why that loan is not paid off.
Yeah, that's exactly right. Yeah, Billy, I agree. That is a big problem for newer investors. He says he's going to give you a call on his next sub-2. Matt wants to know, what's the best way to present the paperwork?
Well, So William, that's where you come into play, because it's really a science in how you talk to the seller, right?
Yep.
I think someone who is looking to sell a home does not call a real estate investor first.
No.
They don't call the bandit sign they see on the corner. They don't call the home investor sign. They've already talked to a realtor, most likely. That's who most people are going to reach out to. And that realtor has already told them in many cases what the problems may be with the house. Whether the house is in need of repair, they're too far behind, they're upside down, whatever the case might be. But the seller already realizes they have problems, right?
Yep.
I just don't see us being that first line of communication to sell a house subject to the debt. It just doesn't make sense. And so, knowing that out there, what I do is, after I get a chance to meet with the seller, oftentimes it's about learning how to be compassionate to their situation, because there's usually something going on negative: divorce, medical, job, whatever it might be. And so it's understanding that out there and not trying to demean them from a position of, why are you so far behind in payments, or why is the house in such bad shape, or things of that nature. So I think being understanding and then being willing to solve a situation is so important. I think what I do is I basically retell them what their options are. Could they sell the house retail? Well, in most cases, probably not, because the house needs XYZ repairs, or maybe they're upside down in some format in which they'd have to come to closing with cash they don't have. And so retail doesn't work. Well, obviously, if retail doesn't work, they go to the investor option for all cash, where the loan would get paid off. And so often that doesn't work either, because the investor offer is going to be less than what they owe in some format.
Right.
Do they really want to be a landlord and try to lease the house? Well, if they're in the foreclosure mode, that's not an option. And so I put back to them in a very polite way what they probably already know. And then I want to step up and say, we do have a solution.
Yeah.
And provide that solution to them and explain to them how it works. Once I do that, I then explain to them how this is going to be a benefit to them, how they're going to be protected with a deed of trust, how, after I have put X thousands of dollars to bring the loan current, possibly, I've spent thousands of dollars to renovate the home, that if I was to default and not make my payments, how they can foreclose on the home, which I don't ever want that to happen, but how they're protected with that scenario. And if they do that, they don't owe me a penny back. And how that, by me making their payments going forward in a timely fashion, how that's going to bolster their credit scenario, right, and help pull them out of the situation that they've gotten into.
Yeah.
And I always tell them, bad things happen to good people all the time, and we're here to help them solve that problem.
Yeah, I agree. It's always best going in, and that's what I tell people all the time. I try to teach my students to approach them first, with a heart to help. If there's some way you can help them, a lot of times sellers are afraid to reach out to the mortgage company and try to work out a solution that'll let them keep their house. A lot of times we can make that phone call for them or show them how to do it, and maybe they can stay. And in that case, yeah.
And William, I don't disagree with that at all.
Mm-hmm.
That's a possibility. And oftentimes they have done that. What is so disheartening sometimes is they'll reach out to the mortgage company, asking to do some type of forbearance or something of that nature, and things just sit. Mm-hmm. And it's like they're asking to do a short sale, maybe.
Right.
Well, you file the application, you file your paperwork, etc., and you hurry up to wait, and months and months and months go by, no payments are being made. The mortgage company comes back and says no. They're so far behind, they can't get caught up.
Yeah. And we see that all the time too. Some of these lenders, especially the B and C lenders from way back or whatever. I had a student did a deal this last month where the person had owned it for 15 years. They got behind. The lender was so confrontational they wouldn't even assist the homeowner in trying to get things straightened out. It was a tough deal to get
No, it
done.
is. But it also, William, I am, what makes this business fun and rewarding
Mm,
is the ability to be able to help people.
right.
It really is. And to know how to make money while we're helping them along the way. But so often these sellers out there, they want to stay in the home, which I understand it's their home. They don't want to have to move. But what I see, which is probably the most prevalent, is their financial position doesn't allow them to do that.
Right. Right.
They want to do it. They really want to try to do it. But what they really need to do is probably move on, downsize a little bit, get their financial legs back underneath them a little bit again. Do this in a way so they don't go through a foreclosure.
Right.
And then maybe when they get their job position reestablished, their medical situation done, they've taken care of the problems, they're able to go out and then buy another house.
Yeah.
And
That's
they
right.
really, it's kind of like going to the buffet. Your eyes are always bigger than your stomach, right?
Oh, yeah.
At least
For
mine are.
sure. For sure.
Well, they think the same thing too.
Right.
And so I oftentimes try to show them why that may not be the best course of action.
Yeah.
There is that case by case basis where it can be beneficial. I just see it all too often where it just doesn't
Yeah.
work. And so you
Right.
try to gently explain to them why it's not a valid thing to do.
Yeah. Hey, Jamie, yeah, there will be a replay. We're going to leave this up for you. We don't take them down, so you guys can benefit from them later. Hey, Tracy, yeah, we're talking about your deal, I think. That's and it's like I told you the other night, that's why you're making all that money. Okay. If it were easy, everybody would do it. Hey, Paul, good to see you. Yes, sub-twos are coming back. I mean, they're still out there now, but they're really going to be back here one day when they turn everything loose. Guys, if you have questions, ask, or I'm going to be asking my questions. So if you want to know something today, what you bill out at, Scott, about 10,000 an hour? You're spending
Well, just like the 10 billion deals, just a little bit south of that.
Okay.
What I find is I get the opportunity at this stage of my career. My currently hourly rate is $3.50 an hour. And it's because I'm very focused in what I do in our law firm, because all we do is the creative finance world, buying and selling. We do landlord tenant rep here in Texas, and we do foreclosures, unfortunately.
Yeah.
Typically with our investor community when we have to. But because of that knowledge base we put together, we're usually able to do things very quickly. And so it doesn't take a whole lot of time trying to learn to do something new.
Mm-hmm. Okay. Let's see. Paul asked, what has changed in the sub-2 practice area since the recession, and what do we need to be aware of?
Nothing has really changed. I go back, William, and I look at what was going on in 08 and 09. And I think I told you, one of the things that saved my skin at that time was I had 700 loans in portfolio. And I was having investors walk away wholesale, but had no owner occupants walk away. But of course, at that time, you could not get a loan. Your banks wanted resolution. The investor world, well, they were offering 40 cents on the dollar to buy a house, so you couldn't go the cash way. You had to find a solution, and the solution was seller financing. And it came to the forefront, but again, nobody knew how to do it. Nobody understood the pitfalls. Everybody had just totally forgotten about the creative finance strategies out there, whether it was buying or selling. And so we put together the disclosures in order to help them get there. So since that point in time, there was no regulation existing prior to 2009 really regarding the subject to or the creative finance world out there. And so of course, since that point, the SAFE Act came into play, where and every state's a little bit different on that. Here in Texas, we have T-Safe, and other states, you just go by the SAFE Act direct, which means they want us to incorporate, if we're, again, buying a home sub-2, we don't have to worry about that too much. It's just the sale. The Dodd-Frank Act came into play. Again, doesn't affect us as investors buying the house. It does if we sell it to a consumer. RESPA doesn't affect us. But it's just making certain that we disclose to our sellers properly what is going on. It is protecting that seller. I used to see so often, William, investors talk about, well, we're going to buy a house into a land trust for anonymity, or get the seller just to give us a deed only, and we're done. And we have no risk, no nothing, etc. Well, of course, I look at that and go, yeah, right, until such time as you stop making payments on the house. And I always like using an example where I had a lady call me out of the blue one day, and she had sold her house to an investor in a land trust. Well, investor one sold to investor two, three, four, and eventually investor five. And no one ever notified the seller who the actual beneficiary was of the land trust. Well, guess what was happening? House was rented out. Investor was pocketing the money. The mortgage wasn't getting paid. Thank goodness I happened to recognize the trustee's name and made a phone call and was able to get the house deeded back to the seller in order to protect everybody involved in that scenario, because otherwise you're going to be in a lawsuit.
Oh, yeah.
So in our industry, even though I'm a lawyer, we want to keep lawyers out of our business.
Mhm.
Doing things smart is the best way of doing, I think, and doing things
Absolutely.
right.
Absolutely. So are you seeing this, Scott? Paul asked, are you seeing an increase right now in the number of foreclosures? And where do you see the foreclosures going right now, since people have so much equity in their property?
I think here in Texas, foreclosures are opening up quite a bit. The traditional foreclosure from a mortgage company, of course, has slowed down, but that is now coming back online. There's still some moratoriums from the federal government perspective for your large mortgage companies and those that are federally insured, but for the smaller guys, no. I do believe that it's going to become prevalent, forthcoming here soon, which is going to open up the sub-2 marketplace quite a bit, because the forbearance issues are out there currently, helping the sellers overcome the inability to make payments. But the problem is that the sellers still don't have a job, or they don't have the income to afford it.
Right.
And even though they put the payments on the back of the loan, which I believe the mortgage companies will be doing, they still can't make the payments. And I think because of that, it's going to open back up. And I think there's going to be a flood of sub-2 possibilities forthcoming.
Jonna asked, is there a specific disclosure you provide to the seller and have them sign and date that reiterates all the terms of the subject to agreement that you use for your protection?
Absolutely. And in fact, I just did an internal class here in my office for our staff to better understand our disclosures that we do.
Right.
But my disclosures between a seller and us as an investor buyer is about 19 pages long. Everybody goes, oh my gosh, it's too much. Now, of course, they're simple disclosures. They're in layman's terms because we know that our sellers will never seek counsel on this. And what it does is it lays out the risk factors, the due on sale clause, the fact that we have seller liability that is not going away, that it's in their best interest. We tell that seller that they have the right to get financial information from us as investors. And you know, William, I was telling my office yesterday that I have never once had a single seller ask me for an application or tax returns. Never. Nothing.
Yep.
I don't know why. And so you see these things and you want to do things right. So I used to see some people in this marketplace going back to 2009, 2010. They would put basic disclosures on a 1-2 page type document, and they'd have the seller initial everything. Oftentimes, this might be an 8-point font, 6-point font, something small. They're never going to read it. And so what I did when I created our disclosure packages was, my thought was, put a title up there, above every signature line, have the seller signing that it's a binding legal document. They don't understand it, consult with their attorney. We do that over and over and over and over again. And even the closing table, we go back and we redisclose again Because what I don't want any seller to come back and say that we as an investor did not tell them X, Y, or Z. And so my theory is after you've signed, 10 different documents all saying the same thing, consult your attorney, and they choose not to do so, it's the best way I know to protect us as investors from sellers out there in this world. We try to hit all the points I think are important, everything from insurance to title evidence to mortgage servicing options to due on sale, seller liability. Here in Texas, the Texas property code that we've got to consider and things of that nature out there. So yes, we do.
Yep.
Okay. All aspects.
Yeah, I don't think you can give too much disclosure. We do the same thing, Scott. In our closing package, we've got disclosure after disclosure after disclosure, because it's important to us that the seller know what they're getting into. We're not trying to, snooker anybody. They need to know and understand, because I'm like you, I don't want them calling me 6 months later, a year later, asking me a bunch of questions. When we part at that point, 99% of the time, we never talk to the seller again. So yeah, that's absolutely.
Oh, well, we get them. Unfortunately, you have that rarity. They call up, they know why their loan hasn't been paid off yet.
Yeah, I mean, it'll happen despite your best efforts, but we
sure.
certainly want to minimize that. So Andrew asked, can you legally pay bird dogs or real estate agents for sub-2 leads without violating any RESPA? And if it is a violation, is there any kind of language you can use to prevent that from being a violation? How can you handle that?
I don't think that's a RESPA violation per se. I think that would be maybe something within the state real estate commission where you are. Okay. And is somebody acting as a realtor? They shouldn't be.
Right.
And I think that if you've got a bird dog, let's just use that term, if they go out and they locate a seller who wants to sell and they don't go to contract, I believe at least here in Texas, they can then refer that person to us and we can go to contract along the way. Now, could we pay that bird dog a marketing fee? Well, we probably could in some format. The key is simply, and the other thing is that bird dog might be able to go to contract with the seller, and then they could assign that contract to us as the end investor and receive an assignment fee along the way in lieu of a marketing fee. And I think the key is just not validating, not understanding what your state real estate commission has out there on requirements of acting as a realtor in some format and not violating that.
Okay. So it's really going to be a rule probably that the agent has to decide if their broker's okay with it or what they can do.
Oh, yeah. I mean, if it's a real estate agent doing this and they have a seller who needs the help, can they refer that seller to us? I think the answer is yes. Could that realtor receive a commission for that? I think the simple answer again is yes. But that's going to be a commission that's going to be put on the settlement statement with a CDA, a closing disbursement authorization from your office. So things are handled properly when you're working with a real estate agent.
Okay.
Most of the time, I don't see real estate agents being our bird dogs.
Right.
Guys like you and I.
Yeah. So Jonna asked if you would be willing to share your disclosure document.
Well, we don't share disclosure documents. Usually most investors don't fill them out correctly. Right. But what we do for every investor is once they have got a deal on the table ready to move forward, is we have them forward us their contract information, and we'll prepare the disclosures for them, get them out to them very quickly so they can then go out and present them.
Okay. There you go, Jonna. Matt asked, once we have done a few sub-2s, is it okay to close the deals ourselves without an attorney? And I'll tell you, in all honesty, Scott, we probably 95% of our purchases we do with a mobile notary. We don't use an attorney. So he's asking if that's okay.
Well, mobile notary is fine, but it's who prepared the paperwork, right, who prepared the deed, et cetera. And really the one point that I push out mostly to everybody is I really like to have that third party intermediary in between a seller and a buyer, whether it's us buying as an investor or us selling as an investor. either way. And the reason for that is at least here in my office, we try to talk with the seller. We try to talk with the buyer. Oftentimes, we try to hop on a phone call with both seller and buyer, answer any questions they might have. Because again, as a closing agent, we don't usually represent either party as an attorney.
Right.
So in doing that, I have the ability to kind of explain how the transaction works before it closes.
Right. And I can see where, especially as a newer investor, it could be advantageous to them to have someone do the closing that can thoroughly explain things, even though you're not representing either one.
Well,
You can answer questions.
Yeah, and I agree. And then the other thing, William, is, of course, is if a problem does pop up, you don't get a he said, she said scenario
Right.
out there. They can call someone else and go, absolutely, we walked through this transaction. We explained it. Absolutely, at that time, they told us they understood exactly what they were doing.
Okay. So Matt asked, what questions should an investor ask an attorney if they're looking for one to work with? What questions should they ask to verify that they're a good one to work with? My experience was, if you're asking them about buying subject to existing financing, contract for deed, those type of questions, and they say, sure, we've done those transactions, we understand how it works, that's a pretty good indicator. What do you think, Scott?
Well, what I find here in the Texas marketplace, unfortunately, is that everybody wants to make a buck one way or the other, whether it's a title company or whether it is a law firm. The first thing is recognizing that title companies cannot close a transaction unless title insurance is issued, and not to let some escrow officer try to put a deal together for you. Here in Texas, we have both fee offices that are offices like mine, where attorneys are in charge, and we have corporate offices. These corporate offices work with other law firms in that instance. But the problem is they don't know how to draft up the paperwork. They think they do, and they don't. And I have seen everything you can possibly imagine. And I often say that trained monkeys can draft either a subject to deed and deed of trust, or a wraparound note and deed of trust and warranty deed. That is absolutely the easy part. The hard part comes down to being able to look over the entire transaction and make sure it's going to be compliant. To be a resource, title companies and escrow officers are not allowed to explain transactions. All too often, escrow officers try to do it when they shouldn't. And of course, sometimes they tell the wrong information. I find law firms that draw up these closing packages, they don't mind drawing up the package. They just don't want to talk with the seller or buyer and walk them through an explanation process. They just want to provide documents. And I am a huge believer in having a resource there to answer questions for buyer or seller, so that when this transaction does close, it's done. And again, we do a lot of mobile notary closings, just like you said that we do. We do the same thing, whether we're closing in Houston or in McAllen or in El Paso or anywhere in the state. But we do get that opportunity to hop on that phone call one time with that seller and buyer and just walk through the deal a little bit.
Oh yeah, for sure. Okay, so that's the mobile notary question there. Let's see. Jonna says, yep, she agrees that her attorney, she's tabletop closings are fine, but the attorney protects her from being classified a vulture investor. The attorney's my protector.
I don't know if that's true or not, because everybody thinks that for some reason, if you close with a law office or you close with a title company, it prevents you from liability. Well, my first response is absolutely not, because in most cases, they don't represent you. Number two, they do not look at your transaction. They're simply preparing paperwork that you've asked them to prepare. And so if that attorney doesn't actually represent you as an attorney to advise you not to do things, they're not going to have any liability in the transaction. And so if you are an investor buying or selling a property in some format, and that process becomes predatory, then we as the investor, who are also in often cases the lender, take 100% of all liability and responsibility. that title company, that law firm, that closing entity is not going to have a liability anywhere in that scenario.
Right. Okay. So it's just like what we say about using disclosures. You can disclose, but if you're doing something illegal, it's not going to protect you.
That's right. You know, I'm going to get back to your question also, William, about finding an attorney. And I think, again, in the subject to world, 99.8% of my closings we do 20 to 30 a month, never involves a title company or title insurance.
Right.
And I always try to educate the investor what their options are in obtaining title insurance out there. And while we're on that topic, let's just talk about it a minute. But anyway, as I'm talking to, it's recognizing that first. Two, if there's going to be a law firm, I think what you said was, do they have knowledge in how to put the deal together correctly? Whether you're buying it subject to, and do they actually know what that means? Because it's not an assumption. It's a subject to, which is different. And it's not a wraparound mortgage, which is different.
Right.
Secondly, I would want to ask them if they're familiar with any other compliance issues out there as well. Do they provide any type of disclosure packaging out there? You don't see a lot of that. Now, I know we've talked about this a little bit on title insurance, just for the investor. This is where I kind of shoot myself in the foot, because I'm both the real estate attorney, I'm also a title attorney.
Right.
So when we're buying a house subject to, William, here in Texas at least, we're a homestead state, and 98% of the houses we buy are homesteads, and there's only a few type of liens that can attach to a homestead. And so we know that if there's an existing mortgage, that mortgage was closed in a title office and title insurance was issued.
Right.
And so what we're looking for is, did anything get recorded between the time that mortgage was originated and today?
Exactly.
That would affect the property. Now, other states have different laws regarding liens and how they may or may not attach to property. So, of course, the investor needs to research that and be a student of that. Here in Texas, it's so often we're only looking, there's only one or two liens that cannot be removed from a homestead. And so then it's also realizing that so often we don't have financial responsibility on the mortgage we're taking sub to. The only risk we're taking is maybe our down payment, or the cash that we're expending to bring the loan current, or for the rehab of the property. And so we make that decision, do we want to get title insurance for that or not?
Right.
And every investor has to make that independent decision.
Right. Yeah. Well, you know, and that's what I tell people about title insurance. If I have a reputable person, someone I trust, taking the title down from my current owner until today, and that looks good, I know if my seller got a conventional mortgage, they have title insurance. If Bank of America did it, Wells Fargo, whoever, I know they've got that. And if that looks good, I'm not interested in title insurance. That's an unnecessary expense. I had a student last week trying to get a deal closed and couldn't get it closed by any attorney or title company he went to. They said the only way they could do it is if it was like, I don't know, $2,500 because of title insurance. And so I had to talk to him about explaining to an attorney what he's doing. And he finally got the closing done for about $600 because they wanted that $2,000 for title insurance. It's just not necessary.
Yeah. You know, and again, we are always going to search title.
Oh yeah, absolutely.
Always. Whether it's an abstracted title or a title search, whatever it might be, but we're going to check it. Yeah. It's just a smart, safe protection mechanism for everybody involved. Because
well, people in trouble, if they're getting a divorce, if they're in foreclosure, whatever, they've got some other issues out there probably too.
Yeah.
So, you know, they're probably didn't pay somebody else, and there's always that possibility.
You know, you talk about divorce. You know, here in Texas, we see a lot of this constantly, where a husband and wife got divorced, but a deed never got conveyed to the other spouse.
Right.
And that spouse who owns the property as per that divorce decree doesn't have the necessary title to convey the ownership. Now, of course, you've got to decide, can you go back to the other spouse to get the deed, or do you have to record a certified copy of that divorce decree and the deed records, which most people don't want to air that entire divorce decree to the public per se. And you got to find a way to get that out there. But also, as our investors are putting houses under contract, it's making sure you know who actually owns it. Is it one spouse, both spouses, or in a probate scenario, are you actually dealing with all the heirs that you need to be dealing with?
Right.
Instead of just one.
Yep. Great information. Okay, Scott, I guess we're getting ready to wrap things up, man. We appreciate everybody that came on today and asked questions. Now, you know, we always, our guest always has a freebie for people that participate. So, so what we've got today, Scott is sharing a 1-hour video of him and a couple of partners. They're discussing how to raise money for paying arrears, for paying for repairs, for whatever you need, even in seller finance situations. So I think a lot of times we call that private money. I don't know, what term do you actually use for it? It's just somebody that'll lend you money when you need something to pay up back payments or make repairs or cash to the seller or whatever. So it's a 1-hour video. Everyone that participated today will get the links a little bit later today to watch those videos. And Scott, tell everybody again how to get in touch with you. I think we've got some people here that are interested in reaching out to you to facilitate some closings in the future. So how would they
I think they have a couple of ways to reach out to us. You know, they can go to our legal website at hornerealestatelaw.com, where they can get any of our contact information right there. Of course, my email is scott@hornerealestatelaw.com. They can visit us at the ownerfinancenetwork.com as well if they wish to do that. And through any of those mechanisms, they can come to us, and we're here to assist them any way it might be. But one of the things I always point out, William, is here in Texas, I've always been the guy that went out and did his stuff. I've never been a trainer, mentor like you yourself are. We do try to provide information to our clients we work with to help them be better at this business. We try to find ways to help answer questions in a mechanism, because I don't have the time, unfortunately, just to take 100 people's phone calls a day and answer all their questions about subject to or owner financing or whatever it might be. And although we will want to do that, and I really enjoy doing that, you know, time just doesn't permit. So we have resources where we try to help people with that along the way, where we can answer those questions that they have that come up. Mm-hmm. And I think in our marketplace, we're always looking for guys who are, I would call, our mentors, who can help people go through deals, put them together and take care of it. And then there are guys who provide our legal resources and other things out there to help them get that deal closed and answer questions for them along the way as well.
Okay. All right. Great. Well, thanks so much, Scott. We'll have you back another time to talk about some other aspect of real estate. If you'd like to come back, we'd love to have you. So
thanks. We love all aspects of it. Thanks for the time. We look forward to helping you and all of your students as well.
Okay. Thanks so much. See you next time.
William. Have a great day, man.
Yeah.